The Supreme Court allowed the appeal in the case of the Chief Manager, Central Bank of India versus MS Ad Bureau Advertising Private Limited on ground of lack of jurisdiction and dealt with the issue of maintainability of the consumer complaint. It held that we see absolutely no scope for interference in order dated 30 August 2023 of NCDRC as regard quantum of compensation awarded. Supreme Court stated that it is quite clear that what is to be seen here is that whether dominant intention or dominant purpose for the transaction was to facilitate some kind of profit generation for person who has availed the service. Therefore, it is our considered opinion that respondent number 1 is not a consumer in terms of section 21D2 of the Act. The precise case of the respondent number 1 before NCDRC as well as this court was that the appellant bank was grossly negligent and deficient in providing banking services to respondent number 1 and consequently caused monetary damage and loss of reputation to it. As per Master Circular on willful defaulters by Reserve Bank of India, all nationalized banks and financial institutions have to report information regarding borrower accounts which are classified as doubtful and loss accounts with outstanding amount aggregating rupees 1 crore and above. These borrowers are classified and reported as willful defaulters by respective banks and financial institutions to RBI, which in turn consolidates its entire information report in form of list on yearly basis. Grievance of respondent towards appellant bank was that has been that appellant bank, despite a no due certificate and despite filing a full satisfaction memo before DRT, incorrectly reported name of respondent number 1 to RBI as defaulter with total outstanding amount of 4.17 crores. This incorrect reporting by appellant bank not only led to significant loss of goodwill and reputation but also resulted in respondent number 1 losing an exclusive advertising tender by the Airports Authority of India, which although was initially awarded to respondent number 1 but was subsequently cancelled for the reason that bank guarantee was required to be submitted and same could not be done. When respondent number 1 approached SDFC Bank for issuance of same, bank refused to do so upon finding name of respondent number 1 in list of willful defaulters. It was business to business transaction as opposed to business to consumer transaction. This is first limb of argument. Second limb, which is a continuation of first, was that the service was availed by respondent number 1 with dominant intention of generating profits and main purpose behind loan transaction was to increase or generate additional revenue for the company. Plain reading of section 21D2 of the Act makes it clear that where a service is availed for any commercial purpose, then the person who has availed such a service is not a consumer for purposes of Act. All the same is subject to caveat which is provided in explanation to section 21D of Act, which clarifies that when a person uses the goods bought or avails any service for sole purpose of earning his livelihood by means of self-employment, then such a person would not be excluded from definition of consumer under the Act. In Leelavati Kirtilal Mehta Medical Trust versus Unique Shanti Developers, court has observed that no straitjacket formula can be laid down for determining whether an activity or transaction is for a commercial purpose and has laid down certain principles which are to be kept in mind. In instant case, the respondent cannot be said to be a consumer is the fact that transaction in question, that is obtaining a project loan, did have a close nexus with profit generating activity, and in fact dominant purpose of getting the loan sanction was to generate profits upon successful post production of the movie titled Kocha Dayan. The court in Shrikant G. Mantri versus Punjab National Bank said that the facts of this case appellant therein was a stockbroker who availed an overdraft facility from bank. The purpose of the which was to facilitate his daily transaction in stock and share market. As collateral for overdraft facility, appellant had pledged his shares which were not returned to him despite matter being settled between parties through one-time settlement. Alleging deficiency in service by respondent bank, appellant approached NCDRC which dismissed the complainant on grounds of maintainability, holding that he is not a consumer under provisions of the Act. When matter came up before Supreme Court, it was appellant's case that he had availed overdraft facility for self-employment. This court found no merit in this argument and held that overdraft facility taken by appellant to expand his business profits and relationship between appellant and respondent bank would be purely business to business relationship and therefore transaction would come within ambit of term commercial purpose. In National Insurance Company Limited versus Harsolia Motors, the court had laid down the determining factors which have to be kept in mind while considering whether services are availed for commercial purpose or not. Two things are called out: whether goods are purchased for resale or for commercial purpose. Whether services are availed for commercial purpose, the twofold classification is commercial purpose and non-commercial purpose. If the goods are purchased for resale or commercial purpose, then such consumer would be excluded from coverage of 1986 Act. For example, if manufacturer is producing product A, for such production, he may be required to purchase articles which may be raw material. Then purchase of such articles would be for commercial purpose. As against this, if same manufacturer purchases a refrigerator, TV or AC for his use at residence or even his office has no direct nexus to generate profits, it cannot be held to be commercial purpose. For this reason, he is qualified to approach the Consumer Forum under 1986 Act. A hospital which hires services of medical practitioner, it would be a commercial purpose. But if person avails such services for his ailment, it would be held to be a non-commercial purpose. Taking a wide meaning of the words for any commercial purpose, it would mean that the goods purchased or services hired should be used in such activity directly intended to generate profit. Profit is the main aim of commercial purpose. But in a case where goods purchase services hired as an activity is not directly intended to generate profit, it would be not be a commercial purpose. It is quite clear. But what is to be seen here is that whether dominant intention or dominant purpose for the transaction was to facilitate some kind of profit generation for the purpose who has availed the service. Therefore, it was the considered opinion of Supreme Court that respondent number one is not a consumer in terms of section 21D2 of the Act.